Moving on with Supreme Court stuff. And this one, 2.64 is a really important one to understand. This would make a great argumentative essay. You have to choose which one you think is best. But judicial activism versus judicial restraint. Judicial activism versus judicial restraint. We're getting here in a little bit of ideology, politics, political parties, some as well. So judicial activism versus judicial restraint. What we're going to do on the back side is we're going to make a T-chart. On the left-hand side, we're going to write activism. On the right side, we'll write restraint. All right, 2.64. We're only doing one card here because this will take a few minutes to actually explain. All right, so what does it mean? So, like, what philosophy does a judge have when they make a decision? That's what we're talking about, judicial philosophy. When a judge has a decision in front of them, how do they make that decision? So, on the activism side, they'll often use their personal views. So, like, what is their politics? And their politics will certainly influence their decision. Activism. Two, a judicial activist doesn't have a problem protecting rights, perhaps that are not even mentioned in the Constitution. So, the kind of famous one that is brought up is the idea of the right to privacy. Although there are aspects of the Bill of Rights that hint at privacy, there's no actual right to privacy listed. But an activist judge would say, well, if you read it here, and then the Fourth Amendment, and then the Sixth Amendment, and you got this in the Ninth Amendment, there's really kind of a right to privacy in here. And so that right's not explicit in the Constitution, but they kind of infer that it is, and therefore they'll protect that right. Of course, the right to privacy eventually led to the Roe versus Wade decision, which legalized abortion. Oftentimes, an activist may call the Constitution a living Constitution, that the Constitution isn't just the sterile words written, 200 plus years ago, but that you interpret, what freedom of speech is based on modern views of what freedom of speech is, or freedom of religion is based on the interpretation of what we mean by freedom of religion today. We don't look at it what was the intention of back in the time when it was passed, but the intention of what we think of, equal protection of the laws today. So modern views, you interpret the Constitution with modern views in mind. The criticism of this from the other side, on the restraintist side, is that the people who are doing the activism, they're legislating from the bench. Like, instead of allowing Congress or state legislatures to make law on controversial topics, instead the Supreme Court is getting involved and deciding controversial topics that really are best left to the people, and they see that as a real problem. So, of course, the classic example again would be the case of Roe versus Wade, where a right that doesn't exist in the Constitution explicitly is decided upon. And the reality with abortion is that it's a very controversial topic, and there's deep-seated differences in the belief. And from state to state, there are deep-seated beliefs. Activist judges had no problem making a rule that applied to everyone, even though it's not explicit. Whereas a restraint side would say, like, well, it's not explicit, so therefore states should do it. I mean, it's just a classic example of an activist versus restraintist view of interpreting law. All right, right hand side. The restrainist vision in the idea of restraint comes from limiting, in this case, limiting the power of the Supreme Court. That Supreme Court, in the Alexander Hamilton view, is the weakest branch, and they got to be careful about getting involved in legislating from the bench, and therefore they should be very restrained in terms of like what decisions they make. They also believe that most controversies when on cultural issues that are like abortion or something else, a similar cultural issue, that should be decided through elections and legislatures. And that is good because then compromises can be made based on views, whereas when a Supreme Court rules on something, there's no more you can't compromise at that point. And a restrainist view would also have more of the idea that, well, if it's not in the Constitution, it's not a court issue. Like, it's just not in the Constitution. So therefore, probably the states maybe every state has a different abortion law. If Roe versus Wade was overturned, it would just mean that every state would have different rules, and maybe there would be some states where it's legal, and other states it would be illegal, and it would just be 50 states and 50 different decisions about abortion. And from an activist viewpoint, that's not good. From a restrainist viewpoint, it's like that's federalism. So, that would be the decision. And then the criticism of the restrainist view is that is the idea that it restricts modern social change. That like decisions on say gay marriage or abortion, these social issues are held captive by the words of the Constitution written over 200 years ago, and it's not allowed to modernize. So those are the kind of two views of a judge's philosophy. Do you go in with the kind of activist viewpoint, and then do you go into with the restrainist? Now, you probably already can figure like which ideology or political party kind of goes one way or the other, and this is probably not going to shock anyone. But the activist side is much more likely to be more of a Democrat liberal sort of viewpoint, and the restrainist side tends to be a more Republican or conservative viewpoint. I purposely left those off beforehand because so that way as people listen to each side, you may have listened to one side and said yeah, I think that makes sense, or maybe you heard the other side and you said that makes more sense. And but if I'd put up Democrat Republican first, some of you would have already said like that's my side. So maybe you or consider yourself more conservative, but you thought the activist side made sense, or maybe you consider yourself a liberal, but actually you actually agreed with the restrainist view. So I kind of wanted to see, to see what you thought there. So you can analyze yourself, or maybe you had no freaking idea and never thought about it before. All right, cool. Activist versus restraint. This is definitely one where you want to grab your whiteboard and try to list out both sides. This would be a great multiple choice essay question on this topic. Thank you.